This anti-gun law is so popular with the gun grabbers that it has exploded like a remote-controlled drone flying across eastern Ukraine, going from one state to 6 states in 6 years. By the way, the guy who invented it wants to be your next president. What am I talking about here? Well, let's put it this way. It has 2 federal courts arguing about how meaningless the Second Amendment is and how defenseless the Supreme Court's ruling is, the Brune decision, to stop the spread. You're gonna wanna hear about this one. Guys, let's get into it. All right, so what the heck am I talking about? I'm talking about background check laws on ammunition purchases. I've got some crazy statistics coming up. Let's break down really quickly what this is for those of us who do not live in one of 44 states where you've got to do this. So California and New York both demand a direct point of sale background check every single time you purchase ammunition. The process is instant. In theory, swipe your ID or do something like that, and basically the system tells the seller if you're approved. There's a reasonably nominal fee, sometimes free, sometimes $1, sometimes about $2.50. You get the idea. It's got a lot of problems, not among them, the Second Amendment. But let's just focus on a more practical problem right now for California, one that they can wrap their heads around over in Sacramento, San Francisco. The result of the system, maybe the design, is that law-abiding gun owners run into bureaucratic red tape, denials when they should be approved, and of course, as always, everyone's favorite, mounting costs. In California, the state that invented this, then Lieutenant Governor Gavin Newsom passed this. Remember the guy who's so incredibly pro-gun?
I'm not anti-gun at all. I'm for just some gun-safe common sense. But otherwise, man, people have the right to bear arms, and I've got no ideological opposition to that at all.
And then just this past week, banned the most popular handguns manufactured in the entire world in his home state of California.
Governor Newsom signed a law banning Glock-style weapons with the so-called cruciform trigger bar. And it takes effect in a couple of months.
January 1st, all of these guns, any Glock or Glock clone, which is a great number of pistols, is banned under the new law.
But again, that's neither here or there. What I really want to talk to you about right now is the fact that, the system, by the way, it's got some problems involving mismatched data, address issues, clerical errors, just at the end of the day, database failures. According to one study I read, of the 102,147, so just over 102,000 people, were stopped from buying ammunition in California. 102,000 people were stopped from buying ammunition in California. Comment down in the field below. I'm gonna give you 10 seconds to do this. Comment down in the comment field below. How many people do you think were actually prohibited persons? So the max number is 102,147. 102,147. In the honor of the great state of California, I'm gonna do a little bit of hand drumming here so we don't get copyright infringement issues. Okay, the answer. How many people should have been prevented out of 102,147? 758. How many of you got that right? The rest were false positives. Wow. So that's literally, according to this study, over 99% of the time that it denies someone, it gets it wrong. I mean, that's a system designed to fail if it's wrong 99% of the time, but I'll let the comment section take it from there. Okay, so as I already mentioned, California is the very first state to enact a law requiring a background check for every ammunition purchase. This was called Proposition 63, passed back in 2016. Let me know if I get that wrong in the comment field. And it went into effect in summer of 2019. Now, as usual, what starts in California rarely stays in California. Just ask anyone from Arizona, Texas, Nevada, Idaho, Montana. I can keep listing states, but you get the idea. Fast forward to 2025, and now 6 states, as I already mentioned, have adopted laws requiring some form of background check in order to purchase ammunition. California, New York, those are the both direct purchase ones where you have to do it every single time you go ahead and try to buy something. And then you got Connecticut, Illinois, Massachusetts, and the People's Republic of New Jersey. So those last four, Connecticut, Illinois, Massachusetts, and New Jersey, have a slightly different approach just really fast because this is the more popular one that's likely to come to your state. These states don't require a point of sale background check every single time you pick up a couple of boxes. Instead, they require that you present a valid permit, basically a license to purchase ammunition. Getting that permit or license requires passing a background check, so there's still a background screening in the process. It just happens earlier, presumably a little bit more correctly, and not necessarily for every single purchase. Once you've got your permit, it becomes like a special driver's license for you to fly through gun shows or gun stores, whatever it is, okay? This system, of course, also carries fees. The government loves their fees, renewal requirements, and administrative hurdles of all their own, but at least doesn't mandate a delay or a system check that is wrong 99% of the time at each and every transaction. Oh, and by the way, did I mention that you go on a government list if you're buying ammunition with, any of these? Thought you might like to know that. So, move east. Our story resumes in the Second Circuit Court of Appeals. The case, New York State Firearms Association versus James. The Second Circuit covers, by the way, Connecticut, New York, and Vermont. This court has a 13-member bench. Okay, so these circuit courts, you start in the federal district court, that's the federal trial court, then you go to the federal circuit courts, then you go up to the U.S. Supreme Court. Those are kind of the levels, those are the rungs we climbed. All judges are appointed for life, and there's a fixed number of positions that can be expanded with time, but there's a fixed number of positions, and as people die and retire, then the president can appoint new lifetime appointees. So it's a really big deal who controls these courts for so many reasons. This court is a 13-member bench. Almost every case that comes through it will get a random 3 judges pulled out of the 13. So 3 are in the game, 10 are on the bench in any given case. 8 are appointed by Democrats, 4 by Republicans, and there's 1 open seat yet to be filled by President Trump this year. I hope I'm not spoiling anything for you here, but a simple fact check. If you're rooting for robust Second Amendment protections, the Second Circuit, and I'll just toss in New York State as a freebie, is not the friendliest place to be. Hey, please excuse this brief interruption to bring you a word from our sponsor, me. Or more specifically, my law firm. You see, what you may not know about me is I'm not only an ex-prosecutor, criminal defense attorney, but I employ a few dozen attorneys all over the great state of Wisconsin. My firm handles criminal defense, traffic law, divorce, family law, as well as estate planning all across the dairy state. We've got different wings of different attorneys doing different things, so you don't have to have some sort of just generalist handling your case should you decide to come in. So what's the ask? Well, look, if you've been with me for my journey of at this point about 10 years and counting, not all of them on my own YouTube channel, but about 10 years and counting of putting out free legal education content that's out there, first off, thank you for joining me and thanks for watching this video. And if all you can do is just keep watching, hitting the like button, sharing it around, commenting, thank you. And I really do mean that. However, if you want to take it one step further, please consider following the directions below, both in the description box as well as in a pinned comment down in the comment discussion field about how you can leave a 5-star review. So again, if you can do that, I tremendously appreciate it. Not only myself, but everyone else want to thank you for doing that too, because it helps us bring our mission across Wisconsin. Don't forget to stick around to the end of the video for our ever popular quote of the day. Now back to the show. So you have this gun rights group who sued to try to block this law from going through. Back on May 2nd of 2024, a federal New York district court judge, that's the federal trial court judge, refused to block the enforcement of specific parts of New York's Concealed Carry Improvement Act, the CCIA. That's the part with all the background checks we're talking about here, all right? So refused to block that, basically saying, and you're, all right, I didn't, all right. We're just gonna keep this going here because it's kind of too funny. You'll see where I'm going in a second. Basically said that, look, history and tradition is good enough, and that's the bar we have to shoot for, because the court said in New York at the trial court level, yeah, look, buying ammo, got it, that's a Second Amendment protected thing. So now the government needs to show that there's basically some sort of law from our history and tradition in this country, generally from the 1800s, maybe the 1700s, you got it. You get the idea. You've been here before, right? That, yeah, they didn't just make it up right now. right? It's got to come from a history and tradition. And you know what? I think this is going to be close enough. That's basically what the judge said, is, yeah, look, I don't think the plaintiffs are likely to win this, so I'm not going to stop the law from going through. All right, you'll see why I was chortling in just a second here. So then the pro-gun folks, the people I already mentioned, from New York State, apparently some people live there who are pro-gun. I know some of you, I'm very sorry. I'm very sorry. They went up to the Second Circuit Court of Appeals, and the Second Circuit looked at that and said, "You are wrong, district court judge. We don't have to think about whether or not it is consistent with our nation's history and tradition of regulating guns and firearms and ammunition and all that kind of good stuff." Why? Because buying ammunition doesn't meaningfully constrain the Second Amendment. Therefore, we don't have to consider whether or not there's an analogous law from our history and tradition, because the plaintiff, that's the good guys of the story, just to make sure you're following along, because the plaintiff, the pro-gun people, can't even show that buying ammunition and going through a background check like this, that doesn't mean anything. Come on, that doesn't mean anything. I'm trying to do a little bit of a New Yorker thing. My mom's from Manhattan, even though I've born and raised in Wisconsin my whole life. So you kind of get that, right? That's what they're saying. Folks, we have two federal courts arguing about how meaningless and easy to sidestep the Second Amendment is. Welcome to October of 2025, folks. Welcome to your New York. The Second Circuit reasoned that unless a law or regulation is so restrictive that it threatens a citizen's right to acquire firearms or ammunition, then it doesn't even implicate the rights protected by the Second Amendment in the first place, because in their own words, quote, regulations on the means of acquiring, transporting, and storing firearms only implicate the text of the Second Amendment if they meaningfully, they italicize that word. I can't do that when I'm talking, other than just doing what I just did. Meaningfully constrain the right to possess and carry arms, end quote. So dear plaintiffs, dear pro-gun, dear Second Amendment, you lose, not because of what the federal trial court judge said, but just because the Second Amendment must suck so much that this law doesn't count. It doesn't burden it in any way. There's no protections here being implicated. See what happened there? This is why what happens in anti-gun states and anti-gun courts, like the Second Circuit Court of Appeal, as well as historically the Ninth Circuit, doesn't just stay local. Because this kind of law and reasoning, it spreads through copy-paste from state legislature to state legislature to DC, from trial court to Federal Circuit Court of Appeals. And before you know it, we've got a map stretching across from sea to shining sea, laws that look like this. This is how this gets normalized. Just because you live in a deep red pro-gun state does not mean you are safe. It simply doesn't. I mentioned that there's a silver lining. There is, and it rhymes with schmort. Hopefully that came through the mic okay. Why am I talking about the Supreme Court? Well, because we already heard from the Ninth Circuit Court of Appeals on this, and that might mean something called circuit split. We're going to touch on that in the next video. If you want me to continue on this thread, let me know. Comment down below what you think about all this. Let me know if you want part 2, where I'm going to be going into okay, we now have a Second Circuit versus Ninth Circuit who went pro-gun. The Ninth Circuit Court of Appeals, which went pro-gun on a nearly identical issue, the California law. Where does that leave us? What does this mean? Our quote of the day, be sure to hit that like button, share around. Our quote of the day comes from one of the best, one of the greats, Patrick Henry, who said, quote, "Guard with jealous attention the public liberty. Whenever you give up that force, you are ruined," end quote. I appreciate you sticking around this long. Are we ruined? I hope not. And I'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.